All right. Good afternoon, everyone. Give me just a second. Let me get this set up. We'll get going. Okay, perfect. I think we are ready to go. Okay, so good afternoon. Thank you all for joining me today. I'll give you a quick little intro about myself and what we're going to be covering on this webinar. My name is Justin Stivers. I was an attorney. I guess I still am. I'm still licensed to practice, but I don't practice anymore. But I was an attorney for over a decade, practicing primarily in the field of probate and estate planning, wills and trusts, but specifically with plaintiffs' attorneys, specifically with trial attorneys. So I did a lot of opening up estates, guardianships, special needs trusts, settlement protection trusts, really all that stuff around the PI world. And then not too long ago, sold that law firm and joined our family's financial planning firm. And now I work almost exclusively with trial attorneys, but on in a different capacity, doing all things around structured settlements, structured annuities, attorney fee deferrals, and investment managed for the clients of you who all are plaintiffs' attorneys working with them. So based out of Knoxville, Tennessee, grew up in Knoxville, was practicing in Miami, Florida for, again, a little over a decade, but relocated to Knoxville. And yeah, it's a little bit about me and about the firm. And then Sage Settlement Consulting is our partner who we do our underwriting and who we do our structured settlements and annuities with. So anyways, glad you guys could join us here today. Probably go for about 30 to 40 minutes, 45 minutes at the max, and then get you to continue on with your day. So all right, so what are we going to be covering today? Some of the topics is going to be just a general overview of comprehensive settlement planning, as well as pre-settlement, bringing you into mediation, and then ultimately finalizing the settlement. We're going to break down the settlement consultant's role in each part of the settlement process and talk about some of the challenges that claimants and attorneys face throughout this entire process. And then we'll wrap up with some important reminders and thoughts to consider before moving forward in your case. So let's go here. So there we go. So comprehensive settlement planning, let's go there. What is settlement planning? Well, first and foremost, it's a comprehensive approach to ensure that the claimant, in this case, the plaintiff, the client, has what he or she needs to enjoy the best long-term quality of life. It's making sure that the claimant has all of the information, all of the options presented to them, that they understand them so that they can make sure they really understand it and it aligns with their needs and what their goals are. And so comprehensive settlement planning not only benefits the claimant, it is also going to help the plaintiff attorney so that you, in this case, the attorney, can direct your time and attention to the case itself. And it's just going to create a more smooth and efficient end-to-end process. So what is the settlement consultant? Who are they? Who is the settlement consultant? That is the person who serves as an advocate on behalf of the claimant and on behalf of the plaintiff attorney. Their job is really to be the point person for anything service-related, product, or potential issue that's going to come up during this pre- and post-settlement process. They might be helping the claimant and the attorney understand what needs to be done before the settlement, which could be resolving liens or identifying and making a plan to deal with any needs-based government benefits that the claimant may be receiving. And they're going to help ensure that the proper language is in the settlement agreement and or the order that's going to be signed by the judge to make sure all of that is proper. They're also going to educate the claimant and the attorney about the available settlement options and attorney fee deferral options so that they can both make informed decisions. And some people like to refer to the settlement consultant as the quarterback, which I think is used in a lot of situations. But in this case, it really is, I think, a proper analogy when it comes to the settlement process. It's their job. It's the settlement consultant's job to see the entire field and help to improve and just really make it an efficient settlement process. So let's look at what happens at the pre-settlement timeframe. Now, there's a fair amount of claimant obstacles during the pre-settlement phase. And I'm sure if you're an attorney and you're watching this, you definitely know that to be the case. Now, depending on the case itself, it could take months. More often than not, this is going to take years. I know in my role when I was a practicing attorney as a probate attorney, I would open up estates for wrongful death cases, and they would last 2, 3, 4 years or longer. So these can definitely take a very long time. There might be medical liens. Very often there's going to be medical liens. There might be Medicare conditional payment issues that need to be resolved, or estate planning issues that have to be resolved. Again, legal matters such as bankruptcy, probate. It's during this time that the claimant really, we've got to know what, if any, government benefits they're receiving, like Medicaid, like supplemental securing income. And so we need to figure out what steps, if any, we need to take to be able to secure and help the client keep those benefits. Each claimant is going to have a unique set of financial circumstances. The family dynamics plays a very big role in all of this, as you all know, as well as the injuries themselves and what we think the future medical needs and financials are going to be in the future. So the key is, my recommendation is always bring in the settlement consultant as early as possible, so that they can know the claimant to really help make the process as smooth as possible. So we're going to look at some of these obstacles in greater detail here. The first is government benefits, and these types we're going to refer to as entitlement. Now, entitlement benefits are benefits that a U.S. taxpayer is, as it would seem, is entitled to. So if you look at a pay stub, you're a W-2 employee, or most employees, you're going to see payroll taxes or FICA taxes. When you pay FICA tax, you're going to earn credits for future Social Security benefits. And you're also going to see that Medicare taxes have been deducted from your pay. So those entitlement benefits are typically going to include Social Security disability, which is going to be referred to as SSD or SSDI, as well as Social Security and Medicare benefits. I'm not going to say these are not as relevant. They're relevant, but we don't really have to worry too much about these when we are planning for the claimant receiving any sort of benefits. The ones that we really need to pay attention to are the government benefits that are needs-based. So in contrast to the entitlement, where you earn credits, you can't earn credits for needs-based benefits. Most of these benefits have a very an asset limit on how much you can have in your bank account or receive before you lose those benefits. It's very, very low, typically about $2,000 for an individual, $3,000 for a couple, and then California is a notable exception, a little bit higher. But that's very clearly all of your cases. If they're getting Medicaid, they're probably getting a settlement greater than $2,000. So it's going to affect them. Needs-based benefits are going to include, but are not limited to supplemental security income, or SSI, as well as Medicaid, or what's called Medi-Cal in California, subsidized housing, which includes Section 8 and public housing, and then food stamps, which now referred to as the SNAP benefits program, or CalFresh in California. Those are all types of need-based benefits that we have to plan around if your client is receiving any sort of settlement. Then we've got liens. This is no surprise to you if you've been practicing. This is a very common thing that delays or disrupts the settlement disbursement. So trying to get this resolved can be a big issue. So you guys are very familiar with liens. Bankruptcy, probably you've dealt with this at some point where the defendant files for bankruptcy. That can delay the settlement or risk the settlement of the proceeds, or certain, if your client themselves declares bankruptcy, how's that going to affect what they're going to receive? And so there's some things you can do with structured settlements that may give them protection from creditors, but definitely something we want to be aware of while we're in that pre-settlement process. And then probate, again, I've mentioned several times, I was a probate attorney for many years, lengthy process. And if you really have any sort of wrongful death case, you're going to be opening a probate to have an executor or have an estate named as the plaintiff. And we all know this can take some time and cause a lot of headaches as well. So those are some of the pre-settlement obstacles for the claimant. There's also some for the attorney as well. The two that I think two primary challenges that attorneys face during this time is time and then money, right? It's hard to determine the accurate case value of it because each case is so time consuming. And so it can take so long, litigation can take so long, it can stretch out for months, it can stretch out for years. And so, that can just be very difficult for the attorney to be able to deal with if you're bankrolling it, if you're having to take out a loan. And just as a practical matter, you've got a client who I'm sure is calling you, wanting to know the status of the case, when they're going to get paid, and it can just be a very stressful process. Now, what is the settlement consultant's role during the pre-settlement? Well, the settlement consultant is going to set the stage during this time for a successful settlement process. Really, they're going to help identify and resolve obstacles to educating the claimant and hopefully setting realistic expectations and to help keep the process moving. I think, just from personal experience, one of the unsung values that a settlement consultant can bring in this process is you as the attorney are very busy handling the case. And I know from the attorneys that I work with, it can be very, how shall we say, just unenjoyable to be getting phone calls from the client regularly saying, hey, I need money, where's my money at, et cetera, et cetera. And that's sometimes one of the hats that I or the settlement consultant that you work with will wear is they're the quote unquote money person. So anything money related or anything thinking about settlement and kind of setting expectations, I tell my attorneys, hey, just kind of pawn me off on that, and I'm happy to kind of wear that hat. So you get to know the client and the family and kind of help set those expectations, which can be really, really helpful and alleviate a lot of stress on the attorney's side of things. So now we're on to mediation. Okay, so what is the settlement consultant's role during mediation? Again, I've said this a couple of times, but ideally the settlement consultant has had a chance to meet with the claimant before mediation, ideally the family as well, because the more information and knowledge they have about the family and the claimant and vice versa, the better, right? Because I can't tell you how many times, more often than not, and it's just the nature of the game. It's not right or wrong, but we'll get brought in at the last minute. Case has resolved, and now this is the first time the client is even hearing about a structure or investments or anything like that. And it can just, that kind of crunch period of having to get the case finalized can be very stressful for everybody. So the earlier the better we can kind of build that relationship. I think it helps make for a smoother process. And so the consultant's role at mediation is just to help facilitate a solution to whatever the needs of the claimant are. They can listen, the consultant can help listen to different offers, calculate options right there on the spot, and really help craft a proposal that works for everybody. I've seen this go a variety of ways. Sometimes the attorney will want me physically present, in which case I'm there. Sometimes they just want me on standby, say, hey, just I'm gonna have mediation today. Can you just make yourself available? Or sometimes we'll just attend virtually. It really depends on the case, on the attorney, on the situation. Mediation prep. There's a range of tools that the settlement consultant can help gather prior to the mediation to help come up with a settlement offer that best reflects the present and future injury-related expenses. So a couple different tools which I'll go over briefly, and you may already be familiar with some of them, but it could be a life care plan, a medical cost projection, a Medicare set-aside, and then rated ages. And so each report is going to consider different aspects of the claimant's individual circumstances, and some are going to be more comprehensive than others. And it's just going to depend on what we're going to use. It's going to depend on the attorney, the claimant, the situation, the injuries, all that sort of stuff. But these are just some of the tools in the toolbox that we can use. So the life care plan, probably one of the more involved tools, but used to prove future damages, a comprehensive estimate of what the claimant's lifetime medical and non-medical needs are going to be, typically going to require an in-person interview. So this one is really, really in depth. And for those bigger cases, we're generally recommending that a life care plan be used. Now I hear good and bad things. You got to find the right company to do them. There's a ton out there, but this is one of the resources we can help with. I don't personally prepare them, but just have a bunch of resources and people and companies that I've worked with. Medical cost projection, kind of similar, but a little bit less in detail than the life care plan. Going to be more of an abbreviated estimate of what the medical care costs are going to be. Still going to review the medical records. Probably not going to have an interview. Again, a little bit smaller cases here. Medicare set-aside allocation. So I'll talk about this one in a little bit more detail, but basically to kind of figure out how much money we're going to need to set aside for potential future Medicare payments. And I'll go over this one in more detail, but this one's very important, and I see this one a lot. And then rated ages. You don't hear about this one too much, but these are going to be issued by the life insurance companies, not on every single case, but they're based on life expectancy, not just the actual age. So for example, someone who's 36 and severely injured could have what is called a rated age of 60, which means there's going to be a lower cost to do the structure settlement because their lifetime is going to be less. They don't have as much time to live, so it's going to cost less for the life insurance company, which means the cost is going to go down. So this is something we look at as well. All right, finalizing the settlement. Again, we've got some obstacles, claimant obstacles here. So they're going to face a lot of different obstacles when it comes to post-settlement life. Settlement is often, I would say, almost always going to be the most money that they and their family has ever dealt with all at once. It's going to be a lot of tax implications. We've talked about the government benefits, eligibility, and how they could be potentially disqualified from those needs-based plans unless they do some proper planning around it. They're going to have to potentially administer a Medicare set-aside, finding affordable medical care, a long-term plan for the money. It's a lot that's going to be very overwhelming at once. Again, it doesn't even matter how sophisticated the client is. Whether they, pick whatever profession, whether they're a doctor or some sort of professional, or, they've got a ton of schooling. Even those clients, if they're getting a large sum of money, it can be very, very overwhelming. Most people don't have any sort of windfall like that all at once, let alone with they're now dealing with injuries potentially, or if it was wrongful death and their family's receiving the money. There's just a lot of emotion behind all of this. So it can be a lot. It is a lot all at once. So there's a couple things that we can offer. One of them being structured settlements. And so this is probably And then there's really two types of structured settlement, but basically a quote unquote structured settlement allows you to get tax-free payments for physical injury cases. On the attorney side, you can get tax-deferred payments for the attorney contingency fees on physical and non-physical injury cases. And I'll go over that here shortly. And you can tailor them. They're very, very flexible for any adult, the age, when they want to receive the money, from minors. And the two options typically under the structured settlement umbrella is going to be the structured settlement annuity and then the market-based structured settlements. Now, the structured settlement annuity, this is probably the gold standard in this space, right? A lot of people are very familiar with it. Now, what is it? How does it work? They're funded by highly rated life insurance companies. They're going to have guaranteed payments. And I say guaranteed, the one thing which would make them not guaranteed is if the life insurance company were to go under or to become insolvent. But generally guaranteed, which is why we're choosing highly rated life insurance companies. They've got a guaranteed interest rate. You can schedule the payments really however you want. They can be monthly, quarterly, annually, biannually, or in a lump sum, or some combination, which is typically what we do, right? Typically, depending on the age of the person, we might say they're going to get $100,000 when they turn 21, and then we're going to stagger the payments over the next 20 years or something like that. It really depends, and this is where, we come in and kind of help plan out what the needs are, what their goals are, and we kind of map out some sort of strategy there. The payments to the claimant are going to be income tax-free payments, including the interest for physical injury cases, meaning they're not paying any taxes on it. So this is a really great strategy for a claimant that, this is money that they're going to get and they're not going to be paying taxes on it. So really, really attractive offer for a lot of people. And for attorneys, while it's not tax-free, it's tax-deferred, meaning you can place the money into one of these and say you're 50 years old, okay, and you want to use some of the money that you just got from a settlement, one of your attorney's fees, you want to use it for retirement income at 65. Well, we could put this money into a structured settlement annuity, allow it to grow over the next 15 years, don't pay any tax when you got the money, and when you put it into the annuity, it's growing tax-free in that annuity. And then at 65, you're going to start receiving those payments from that annuity. And now you're going to pay taxes at that point. So, a lot of attorneys, get confused. It's not the same as how it is for the claimant. You are going to pay taxes on it, but you get that growth where it's tax deferred. And also, it's likely that at 65, if you're retired, your income is going to be less than it was when you were working full-time at 50. So you're going to be in a lower tax bracket, which means you're going to be paying less taxes overall. So again, very attractive option for attorneys for their fees themselves. And then there's no ongoing fees with these products. Okay, so how does this work? You'll see on this chart here. So basically you've got the claimant and you've got the plaintiff attorney. You're going to sign the settlement agreement. The defendant / insurer / QSF, Qualified Settlement Fund, is going to, obviously, the two parties here have signed an agreement. Now, the defendant doesn't want to be in the business of, like, let's say that it's, Allstate Insurance or whoever the defendant or the carrier is. They don't want to be in the business of making payments to you and the client over the next 30 years, right? It would just be too much for them. And there's some other tax reasons they don't want to keep making those payments. So what they do is, once you figure out what life company is going to be issuing that annuity, let's say it's MetLife. Well, MetLife is going to use their assignment company, right? Which is basically, most major life insurance companies are going to have an assignment company, which is a subsidiary of their company. And that assignment company is going to sign a release with the defendant, basically saying, defendant, you're no longer on the hook. You don't have to make any payments or anything like that. The defendant is going to give the money to the assignment company, and then the assignment company is going to pay the money to the life company, who's going to then pay the money, all the future payments, to the claimant or to the plaintiff attorney if they're doing the attorney fee deferrals, right? So that's kind of the structure of it. Plaintiff gets the money, they sign the settlement agreement with the defendant. The defendant's going to contract with the assignment company. The defendant's going to give the money to the assignment company. Assignment company is going to have a release signed with the defendant. Basically, the assignment company is saying, we're taking over. We're now in charge of making those payments. The assignment company is going to pay the life company, i.e. the structured settlement provider, which is typically the parent company of the assignment company, and then the life insurance company is going to be making the payment. Really, the assignment company pays them, but that's kind of the structure of how that works. So how did the structured settlement stack up against traditional investments? I come up across this a fair amount. What are the rates? Well, if you're looking at the chart here on the far left, you'll see the structured settlement fixed rate of return going from 3% to 6%. Now, these rates vary on a daily basis. What I have been seeing right now is rates have been hovering around 4.6, somewhere around that. Again, they change all the time. So let's just say we use 4% as the fixed rate of return. That's the fixed rate of return the client and or the attorney is going to get for the remainder of that structure. Well, if you took the 4% and came across, and remember, there's no taxes being paid on it. If you put that money into a traditional investment account, like a brokerage account, think stocks, bonds, that sort of stuff, your Vanguard, your Fidelity, you would have to earn the equivalent of 5.33% in order to get the equivalent of the 4%. Because remember, you're paying taxes on all that money. And that's also saying if you're in the 25% tax bracket, meaning that's your tax bracket. If you go further down, you're in the top tax bracket, you'd have to get 6.62% to have the equivalent of the fixed rate of 4%. And this is actually that's even going to be higher if you are in a state that has state income tax, right? So that's something to pay attention to. So it's very, very competitive. And what I think a lot of people like is some people are just very conservative and they want that guaranteed rate. I would say I also see a lot of times where we do both, where we might invest some and we might put some into a structure. Now, there is another product under this umbrella of structured settlement called a market-based structured settlement. Very similar, works almost identical to the annuity that we just talked about. Payments are going to be income tax free to the claimant. You can still defer them for attorney's fees, so you still get that growth and get to defer paying taxes. But the difference is you still get that security, but you get to tie it to the market, i.e. to the stock market, and get some potential growth there. So a lot of people like this. It works very similar to what I just showed you on the annuity, except when you get to the assignment company transferring the funds have to then be outsourced to a financial advisor or a financial institution so that the money can be invested. And that's something that we can do as well. And then the money is then placed back with the life company and the money is distributed. So this is another great product that's available. Now, us as well, some people just say, nah, I don't want to mess with this. I'd rather just invest the money. And that's one of the unique things about us is we're able to, because we're fiduciaries and our financial planners, we can also just say, hey, no, you want to do some of the fixed annuity, we can do that, but then we can also do investment solutions as well. So again, funding options for the market-based structures. You can do a hybrid product. Basically, it invests in both fixed rate structured settlement annuities and then also something like a Vanguard growth fund. It's uncapped. index-linked structured settlement annuity. And so again, good option for the right person. So this is something we do as well. Now, by far and away, I would say the structured annuity is probably the most common thing that we see. But this is, I won't say this is new, but this is a little bit newer, and we're starting to have more interest in this. Now, some other things just to be aware of: special needs trust. Again, have a career of drafting special needs trust. This can be very helpful to supplement needs while preserving government benefits. So the funds in the special needs trust, they're going to be meant to pay for goods and services that aren't already covered by needs-based benefits. So, for example, you could, if you've got a settlement and they've got their government benefits, well, the government benefits are Medicaid, food stamps, whatever it is, they're going to pay for what they're going to pay for. So we don't want to put, the $300,000 in their bank account and cause them to lose their benefits. So we're going to put the $300,000 into a special needs trust, and that money we can use for certain things that the government benefits are not covering. Things such as clothing, transportation, home modifications to basically retrofit the house. So, if somebody's now in a wheelchair, personal hygiene products, the very specific things that you can use for. But that way the client can receive the $300,000 or whatever the amount is and not lose their government benefits, which we don't want them to do, and they can still have access to the $300,000. Now, they can't just use the $300,000 for anything and everything that they want, which is, again, where providing education to the client becomes very, very important. And this is a real sticky point for a lot of people, I think, because trying to educate them on like, hey, look, if you're getting $10 million, maybe we're not so concerned about it. But if you've got some serious medical bills and you're only getting $100,000, we don't want to give you that $100,000, because as soon as you put that into your bank account, you lose your government benefits. You got to spend that $100,000, most likely going to be eaten up by government benefits, or eaten up by medical expenses and things like that. And then you're going to have to wait typically 5 years to now try to reapply. So not to reapply, but there's a look back period and all of that. So anyways, way to protect the benefits. Now, to protect the Medicare trust fund, which is, the government trust fund where all the money is allegedly to pay for Medicare, the MSP Act says that Medicare's interest must be considered. And the preferred method for doing that when it comes to personal injury settlements is a Medicare set-aside. So if the claimant is Medicare eligible, 65 or older, or they're going to be eligible in the near future, an MSA probably should be considered. What the MSA does is it sets aside funds from the settlement to pay for injury-related goods and services that would be otherwise used to be covered by Medicare. Now, MSAs can be administered individually or professionally administered, but there's just very strict requirements and reporting requirements. And so, it's really recommended that you have an outside party do this for you. We don't do it, but we work with a lot of companies that do. The claimants can also set up these MSAs with a lump sum from the settlement or with a structured annuity. So the structured annuity can actually pay into the MSA, and that really allows the claimant to retain more of the settlement funds. And the big picture here is what the government is saying is, look, you're going to get Medicare, but you also, as part of the settlement, you just got all this money to help you pay for medical expenses. So we don't want you to just say you're not going to use any of that money for your medical bills and Medicare is going to float the cost. So you need to set aside some of the money from your personal injury settlement and use that for future costs that Medicare otherwise would be paying for. And then lowering healthcare costs. Some companies offer access to discount on with savings on medical bills, prescription drugs, medical equipment, different things like that. Now, what are some obstacles for attorneys post-settlement? Well, the attorneys, a lot of times you might not be aware that there's a way to mitigate tax liability on the contingent fees. So one of the things that you can do is we can do what's called this attorney fee deferral, which I'm going to talk about here in a second. And then also the other big risk that I see is the attorney and or the law firm runs the risks of future malpractice claims if the claimant is not sufficiently educated on all of their settlement options and how things, the big one that I see is what I've been talking on a lot here is the special needs, that they didn't know if they took this money, they're going to lose their government benefits. And those settlement agreements just don't have the right language or proper disclaimers weren't filed, signed by the client. So the attorney fee deferral, I've talked about this, but again, you get to let the money grow tax pre-tax. So you get $1 million. You're not going to pay on the $1 million. You put it into this annuity. It grows tax deferred. You're not paying any taxes on it, which compounding interest, you get the benefit of that. And then you get to, when you take out the money, you pay taxes on it at that time. There's no contribution limit. You can put in there as much as you want, which is great, contrary to other retirement accounts like a 401k, an IRA, a SEP IRA, a Roth, all of which have income and or contribution limits. Again, we've talked about the different options between the settlement annuity and also the market-based structured settlements. And then really just two main requirements. You can't receive the money outright, which is a big thing. I harp on all the time, probably annoyingly to the attorneys that I work with, but I just keep telling them, look, do not take a check from the defense that is made out to your trust account or that's made out to you. As soon as you get that money, and this goes for you and for the client, that money basically can never touch either of your hands. We need that check to be made out to the life insurance company, to whoever's going to be funding the annuity. So that's a big one. And then number two, you got to have fee deferral language. It's got to be in the settlement agreement. The defense has to agree to this. So one caveat with this is that not all defendants are going to allow it. Most will, but this is another thing that we can add some values if we're dealing with a larger insurer. Get on the call with them and kind of walk them through this process if they're not familiar with it. So finally, here's a couple disclaimers that we use to protect basically ourselves, the plaintiff attorney, and then ultimately the claimant. We want to make sure that the claimant really understands all of the available options and that they're making the most informed decisions. So here these are all forms that, if you just say, hey, Justin, can you send me a blank copy? I'm happy to do this, send one out to you. So we've got settlement option disclaimer. We've got government benefits disclaimer, and we've got a Medicare set-aside disclaimer. So wrapping up. Now, when you initially reach out to your settlement consultant, there's going to be some information that you need that really helps expedite the process. So I've got intake forms. I've got different stuff. I've got lengthy ones, shorter ones. These are really the main things that we're going to need. The name, the date of birth, amount to structure or amount that we're dealing with, an approximation, social security number, type of case, is it wrongful death, car accident, who's paying the settlement, because that's important as to whether they'll fund a structure, whether they'll do attorney fee deferrals, if the case has settled. Big one is if the client's receiving any sort of benefits, and if they are, what are they? And then are there any ongoing medical needs or concerns that are going to affect life expectancy? That's where we get back to that rated age. Now, this is the bare minimum, all right? And I get, I often will get referred, hey, Justin, case just settled, $300,000. Can you run me a couple quotes? Well, yes, but no. I've got to have some information. And these are typically the things that I'm going to need, or else I can't get I just literally cannot get it. So these are the things that we would need to really get started. So it's good if you, and again, I send my attorneys checklists, and I can send those to you if you want a copy of one, or to your paralegal, legal assistant, but those are the things that we need. And just a couple of important reminders, before we wrap up. You want to bring in the settlement consultant as soon as you open the case. A lot of times it's not on probably not when not right when you sign up the case, but the sooner the better, right? I'll just say that it's never too early to bring me or to bring in your settlement consultant to the case, just because it makes the process much smoother. And then when we finally do get to that, where we're trying to settle everything, the client is not like, wait, who's Justin? What is this? I don't know what this is. We've had months or even years of a relationship built. And so it makes the process a lot smoother. Remember, specific language has to be in the settlement agreement that allows the claimant and the attorney to structure. We'll provide you with that language. It's got to go in the court order most of the time. The insurance companies are not going to fund it without that. So, it's great that you resolve the case with the defendant, but don't just go submit an order to the judge. Send us the order. Let us give you the language. We'll help you draft the order so that you've got everything that you need. And then just remember that the attorney, you can choose to defer your fees, even if the claimant doesn't want to defer theirs. So if they say, you know what, no, just give me the money outright. I know I don't want to do it. You can still defer yours, right? And so we've got a very carefully curated network of leaders, industry leaders in almost every possible settlement related service and product. So if you ever need anything, just let me know. I encourage you to just really embrace a comprehensive approach rather than just focusing on that structured settlement. So contact me if you need anything, if there's anything that I can do. I'd be happy to help. Here's my information, Justin at stigerswealth.com. I look forward to working with you here in the near future. Again, reach out, any questions, I'm happy to help. And appreciate you all taking the time with us today. Have a good one.